Hello, everyone. Thanks to all of the participants who have joined us today for this roundtable discussion on the International Criminal Court's 20th session of the Assembly of States Parties. My name is Milena Asterio, and I'm the Managing Director at the Public International Law and Policy Group, and also the Charles R. Emmerich Jr., Calfee, Halter, and Griswold Professor of Law at Cleveland State University's College of Law. I will be moderating today's roundtable, and I'm honored to be guiding this conversation with my esteemed colleagues and experts. The Public International Law and Policy Group is a global pro bono law firm providing free legal assistance to parties involved in peace negotiations, drafting post-conflict constitutions, war crime prosecutions, transitional justice, and human rights documentation. In the past several months, our team has been fostering the development of a thought leadership initiative. This initiative focuses on a range of topics, from prominent international law issues to pressing global conflicts. Through organizing periodic roundtables, our aim is to share expertise and reflections from our work on peace negotiations, post-conflict constitution drafting, and war crimes prosecutions. The Assembly of State Parties functions as a management oversight and legislative body of the ICC. It is composed of representatives of states parties that have ratified or acceded to the Rome Statute. Currently, there are 123 ICC states parties. The ASP, the Assembly of States Parties, convenes annually in November or December on a rotating basis, either in The Hague, in the Netherlands, or in New York in the United States, to decide on pertinent matters for the functioning of the courts. The 21st session of the Assembly of States Parties took place in The Hague in the Netherlands and concluded in early December. PILPG had the largest delegation in person in The Hague for this ASP, which actively followed the key decisions, discussions, and side events. PILPG also organized a side event of its own on the topic of Shocking the Conscience of Humanity from Gravity Theory to Practice, which was a book launch for one of our today's panelists, Judge and Professor Meg de Guzman, and that side event was also co-hosted by the Gambia. In today's expert roundtable, we will be discussing key decisions and takeaways from the 21st session, as well as some recent developments at the ICC. The roundtable will be 60 minutes long. Our esteemed panelists include Kate Gibson, Judge and Professor Margaret de Guzman, and also Professor Yvonne Dutton. Today's event will be recorded and subsequently posted on our website, and we ask that you please submit any questions that you might have for our speakers using the Q&A function, and we will do our best to answer your questions either throughout the event or at the end of the event. Now, please allow me just a few moments to properly introduce our panelists. We're honored to welcome Professor Yvonne Dutton, Senior Legal Advisor at the PILPG and also Professor of Law at the Indiana University Robert H. McKinney School of Law. Professor Dutton is an integral part of PILPG's team working on our engagements with the ICC, including support to the Trust Fund for Victims, PILPG commentary on the gender persecution policy, which was just recently launched by the Office of the Prosecutor at the ICC, an amicus brief in the case of Dominic Ongwen, as well as many other matters. She's the author of a 2003 book entitled Rules, Politics, and the International Criminal Court, Committing to the Court. We're also honored to welcome Kate Gibson, Senior Legal Advisor at PILPG, who's currently representing accused persons in front of both the ICC as well as the Kosovo Specialist Chambers in The Hague. In July 2018, she was appointed as legal consultant to the Independent International Fact-Finding Mission on Myanmar and currently represents a group of Rohingya survivors in Cox's Bazar, Bangladesh, in proceedings before the ICC. And finally, we're honored to have Judge and Professor Meg de Guzman, Senior Peace Fellow at the PILPG, the James E. Beasley Professor of Law and co-director of the Institute for International Law and Public Policy at Temple Law School, and also a judge of the Residual Mechanism for International Criminal Tribunals. Her scholarship examines the role of international criminal law in the global order, with a particular focus on the work of the ICC. For full speakers' biographies, please visit the PILPG website. Welcome, everyone, and thank you for agreeing to participate in today's panel. And my first question goes to Yvonne. Yvonne, could you please tell us a little bit more about the 21st session of the Assembly of States Parties? What were your main takeaways and what were some key decisions made at the ASP?
Sure. Thank you, Milena, and thank you, PILPG, for putting this together today. I did want to say, yeah, a lot of us, we had a very large delegation at the Assembly of States Parties, which happened from about December 5th through December 9th or 10th, if I recall. And there were a lot of, so there were general meetings, and then there were a lot of side events. And so one thing, the side events, many of the side events, of course, as you might expect, focused on Ukraine, and sort of what kind of investigation was ongoing by the Office of the Prosecutor in Ukraine, and sort of what was happening there, what the status of that investigation was. Also, a lot of several sessions, I would say at least, side events focused on the crime of aggression and how the crime of aggression could be prosecuted, given that in this circumstance with Russia and Ukraine, since neither is a member of the ICC, a full member, thus the ICC does not have jurisdiction over the crime of aggression, Russia's aggression, how that would be prosecuted. And so there were some sessions on the possibility of special tribunals to do so. And so I know a number of us attended those, and I'm sure there'll be some more discussion about that during this session. There was also, so during the assembly itself, there was a lot of discussion, and I sort of heard some side discussions, in the sort of general meeting room about the budget, right? So this is when the Assembly of States Parties decides on the budget for the court. There was an unprecedented budget increase of 12.2% as compared to 2022. And I think many people know that the budget increases have been kept relatively minimal for many years. It's always a contentious point. So this was welcome news to see that there was a budget increase and that, it was fairly significant. Nevertheless, I mean, one thing to mention, of course, is the ICC's budget, could be by many considered, quite low, and even this increase could be considered low given the substantial inflation and the number of situations that are being investigated and prosecuted by the court. There always seems to be a greater interest in having the court handle more matters rather than fewer matters. Also, in sort of the larger, in terms of the ASP itself and sort of those larger meetings, 6 new members of the Committee on Budget and Finance were elected. And then there was an omnibus resolution that was included in a new paragraph that and I will just sort of quote it, that reaffirms the support for the consistent implementation of the court's mandate across the situations and cases under its jurisdiction in the interests of justice and the victim's right of access to justice, and stresses the need for sustainable resources for all situations and cases, as well as cooperation with the court to that end. And so the resolution, it's a resolution, but it essentially upholds the need for the court's mandate to be exercised equally across all situations before it, and to ensure that the court has sufficient resources to fulfill its mandate. I will also note that the Assembly adopted an amendment to the Rules of Procedure and Evidence regarding the continuation of proceedings in the temporary absence of a judge for illness or other unforeseen urgent personal reasons, which was discussed jointly in the study group on governance and the working group on amendment. Now, there were many other things that happened, of course, and I'm sure that our moderator might be asking some of our other panelists to share their, there's some of their takeaways. Thank you.
Thank you, Yvonne. Let me turn to Meg next. Meg, in your opinion, what were some of the highlights from the last ASP? Anything that you would point out to our audience members?
Thanks, Milena, and thanks to PILPG for organizing this event and for including me. Of course, I'm speaking in my personal capacity, not as a judge at the IRMCT. In addition to what Yvonne mentioned, I think one of the most interesting aspects of the ASP in some ways, coming from a US perspective, was the very new posture that the US has taken toward the ICC. Right? This was the second ASP since the Trump administration. The first one was online, and the US had delivered a written statement at that ASP. This time there was a full delegation, which headed by Beth Van Schaack, the ambassador at large for global justice issues, which was very active at the ASP and gave 2 formal statements, making it clear that the US is going to do what it can to support the court. And of course, everybody knows there are limitations, including legislative limitations on what it can do. But, and this is not directly at the ASP, but after the ASP, legislation was actually passed that allows the US to provide assistance, at least with regard to the Ukraine situation, which, while perhaps disappointing in that it's limited to the Ukraine situation, is in fact at least a step in the direction of the US being able to provide assistance to the ICC, and may in fact, be amenable to future kind of augmentation. So the US position, and in particular, the clear signal that it intends to provide assistance to the court when it can was really interesting. Another thing I found interesting was with regard to Ukraine and aggression. As Yvonne was saying, there was kind of ceaseless talk about Ukraine, and in particular about the idea of creating a specific aggression tribunal of some sort. And from what I could tell, there seems to be, and others may have more information about this, but there seems to be increasing support for some kind of institution to deal with aggression in addition to the ICC, specific for Ukraine. But the prosecutor was very clear that he does not support any kind of additional institution. And that's interesting because it created a kind of tension between what at least a lot of delegations, I think, were talking about informally in the hallways, and the position of the ICC's prosecutor, which is, and he said it very clearly in the side event in which they launched the prosecutorial strategy, that the international community should be looking to avoid fragmentation, that the Rome Statute has the crime of aggression, and that if there are gaps in its ability in the ICC's ability to prosecute that crime, those should be addressed. That the ICC budget is, this wasn't his word, but he implied, inadequate for the task. And I think many people agree with that, despite the increase, which once you account for inflation, isn't that exciting of an increase, I think, but still it's an increase. And, having money siphoned potentially away from the ICC toward a new institution to try people most likely in absentia for aggression could potentially undermine the work of the ICC. So that tension I found really interesting. And then last, and this is sort of a smaller comment, but I attended the side event on Ecocide, which I've been quite skeptical of since the inception of the idea. And I have to say that I was somewhat more persuaded this time around by the statements that were made, in particular, actually by the youth leader who spoke, and spoke about the symbolic importance to youth working on issues related to climate change and sustainability. And so I think it's something that it's worth giving more attention to, despite the practical challenges. And I will leave it there.
Thank you. Now, Kate, I did want to hear your take as well, some of the highlights from the ASP, and in particular, those of us who were there definitely, saw and heard about the essentially, strike that had been ongoing by some of the defense counsel, and then also the decision to not allow defense counsel to actually attend the ASP in their formal capacity as defense counsel. So tell us a little bit more about that.
Thanks very much, Milena. And it's a real pleasure to be here with you and Judge de Guzman and Professor Dutton, particularly to be given a forum to talk about this issue, which I think was one of the more interesting aspects of the ASP this year. So essentially, obviously, the lawyers that you see in a courtroom at the ICC are either prosecution staff members or independent counsel who are representing accused and victims. And as independent counsel, these lawyers and their team members aren't staff. And their working conditions are sort of objectively precarious. So unlike court staff, independent counsel don't have proper working contracts. They're not entitled to any annual leave or sick leave. They're not entitled to parental leave. They have no pension, no healthcare. They can be arbitrarily dismissed. They've got no notice periods. And the rates of pay of these independent counsel, so everyone on the teams representing victims and accused, is sort of 30% lower than the equivalent counterparts in the Office of the Prosecutor. And those rates of pay have been like that at the same level since 2013. So 10 years without any increase, even for inflation, at a time when, the cost of living in the Netherlands has really increased. This is a fair trial issue. Counsel are entitled to the resources that they need to be able to competently and effectively represent their clients, whether or not they're victims or accused. It's also a diversity issue because this sort of chronic underfunding of independent counsel affects often women and junior women. And it's also a barrier to sort of geographical representation within these independent counsel teams because unlike court staff, victims lawyers and defense lawyers don't get relocated to The Hague. So even if they pay for themselves to come, they don't then have any social protection. So it really discriminates against lawyers who aren't from the EU and lawyers who aren't independently wealthy. So, these issues have been on the table for a long time. And sort of after 7 or so years of trying to achieve some reforms, the ICC registrar announced that these issues would not be put on the table at ASP 21. And in response, we saw that junior members of sort of support staff of defense teams and victims teams, as you said, Milena, went on strike and sort of stopped working with the support of their clients and their counsel and spent the ASP week in the morning standing outside the ICC premises and then on 2 afternoons outside the actual ASP building with the aim of really trying to talk to ASP state parties and members of civil society about these issues and engage with them. In terms of sort of the tensions that led to at the ASP, we think that it was this strike that led the ASP Secretariat to take this, previously unprecedented step of banning all independent ICC counsel and their teams from attending any of the ASP sessions. So concretely, you have these teams of lawyers who are currently appearing in cases before the ICC who were banned from attending an event, the purpose of which was to discuss these cases at the ICC. And it was really just such a clumsy and disappointing decision, which not only looked so bad, but it really sort of dragged the ICC backwards in terms of these sort of fundamental recognitions that Defence Counsel and Victims Counsel, play an important role in the International Criminal Justice Project and aren't sort of this enemy to be excluded or maligned. Because I could talk about this for a long time, so I'm going to cut myself, but I'll just say, the people that were excluded from the ASP are practitioners who've been in these courtrooms, right, for years and who have been engaging with victims communities and perpetrators and the beneficiaries of international criminal justice. And so I have a lot to contribute to the conversations that were happening inside the building. So I think that the ICC community and the ASP really missed out by putting this exclusion in place.
No, thank you, Kate. Absolutely. Now, switching gears a little bit, I wanted to talk about a few more specific developments from the ASP. So at the 2022 ASP, there was a presentation and formal launch of the Office of the Prosecutor's new gender persecution policy. Now, PLPG had the honor to work on this and to submit commentary to this policy last year. Both Yvonne and I worked on this on behalf of the PLPG. And so I wanted to turn to Yvonne and ask you the following. What are some of the key points from this new policy, and why is it particularly important to have this new policy in place now?
Thanks, Milena. And I'll just start with a little background, but yeah, there was a whole side event where this was presented, very well attended, a lot of interest in this new policy, a lot of CSO, civil society representatives at this launch. So a very big deal. But I'll start with a little background. So I first want to note that, under the prosecutor Fatou Bensouda, the Office of the Prosecutor did implement a policy in 2014 on sexual and gender-based crimes. And that paper recognized that sexual and gender-based crimes are amongst the gravest under the Rome Statute, and that there can be many challenges and obstacles to effectively investigating and prosecuting those crimes. So the OTP, even at that time in 2014, resolved to focus, resources in the future on investigating and prosecuting sexual and gender-based crimes, wherever the evidence would exist to do so, and to provide clarity and direction on gender issues in all aspects of its operations. And some progress has been made in that regard. So after the publication of the 2014 policy paper, and this increased focus, the court witnessed, a sharp uptick in the investigation and charging of sexual and gender-based crimes. And so within those 4 years after the policy's enactment, sexual and gender-based crime prosecutions grew to 50% of the crimes charged at the ICC. And every investigation since 2014, except for that into the situation of Palestine, includes allegations of such crimes. So as mentioned, at this December meeting, the Office of the Prosecutor announced the new policy, the 2022 policy on gender persecution. And this policy builds on the 2014 policy, but specifically focuses on this crime of gender persecution. And now I'll note that the Rome Statute is the first international criminal law statute to recognize the crime against humanity of persecution on grounds of gender. So as set out in this new policy, the 2022 policy, the office specifically commits to paying particular attention to the commission of sexual and gender-based crimes, including specifically the crime of gender persecution at all stages of its work, from preliminary examination, investigation, sentencing, appeal, and reparations. And I feel I should set out the definition of gender persecution here, just in case anybody doesn't know. Under Article 7.2g of the Rome Statute, persecution refers to the intentional and severe deprivation of fundamental rights contrary to international law by reason of the identity of a group or collectivity. So gender persecution in particular is committed against persons because of sex characteristics and or because of the social constructs and criteria used to define gender. So also, I do want to note that there are many persons, and this is mentioned in the policy actually, to show how inclusive it can be, who can be victims of crimes of gender persecution. And so the policy mentions women, girls, men, boys, LGBTQI plus persons, and subsets of these groups as well. And the policy outlines that gender persecution may be used by perpetrators to enforce social constructs and criteria through imposed discriminatory regulations that violate fundamental rights. In the policy, an example, it notes the ideology of the Islamic State in Iraq and the Levant has been described as grounded on a systematic discrimination against persons on the basis of gender and gender expression, which has included torturing and killing those deemed not to be in conformity with their understanding of gender roles. So this 2022 policy explains the need to focus on gender persecution, explaining that gender discrimination has not historically been identified as a driving factor of violence under international criminal law. Instead, there's been this tendency to view sexual violence as kind of a gender neutral crime, which thus ignores this gender aspect. So this is a real focus now on the gender aspect. So one thing that was really highlighted in the 2022 policy is the need to consider the possibility of the existence of facts constituting gender persecution at all stages of the office's work, preliminary examinations, investigations, and prosecutions. And the policy notes some of the difficulties of uncovering gender persecution. And that's in part because of the challenges and sensitive nature relating to engaging with victims and witnesses of such crimes. And so the policy emphasizes the office's willingness to identify appropriate experts to assist in gathering facts and supporting victims and witnesses. It also places great emphasis on training, explaining that it will train all who engage in the investigatory and prosecutorial processes so that all persons have the relevant knowledge to properly investigate such crimes and to properly and respectfully interact with victims and witnesses. So one thing that I would say that really stands out from the 2022 policy is its future planning. There's this section of the policy entitled Institutional Development, and it envisions ongoing training programs for personnel. It involves identifying, documenting, having best practices, documentation. It envisions recruiting persons with the required expertise in the field, also hiring external expertise when needed. It notes that Prosecutor Khan has appointed advisors and recognized experts with expertise on sexual and gender-based violence, such as Professor Lisa Davis, who worked on this policy to help develop this the policy of the office further. And one thing that I will say is, again, this was very well attended. And I really feel there was a real enthusiasm about this policy. Many representatives from the CSOs spoke up very favorably, seeming to be very encouraged that there will be this focus on something that has not perhaps except in the last few years, been sufficiently focused on. And this was very welcome, it seemed to me.
Definitely. And I, having been in the audience there as well at the launch, I shared the same impression. Now let me switch gears a little bit and let me go back to Meg. Meg, I wanted to talk a little bit more about the side event, which PILPG co-hosted with the Gambia, which was a book launch for your book, which is recently released, Shocking the Conscience of Humanity. Could you share with us some of the key points from the book, as well as anything from the side events?
Sure. And I want to just start by, again, reiterating my extreme gratitude to PILPG, as well as the Gambia for hosting it. It was a lot of fun. We had an amazing panel of experts who came with comments on the book: Marika DeHoon, Rod Raston, and Marie O'Leary, taking it from different perspectives. Marika, also being an academic, talked about aspects of sort of jurisdiction and theories related to the international community. Rod, being at the Office of the Prosecutor now for many years, spoke from a very sort of practical perspective. And Marie, who's in the Office of the Public Defense, had some really interesting things to say about the defendants' rights and so on. So the event itself was focused on the sort of theories that I set forth in the book and their practical application at the ICC. And of course, I don't have time to go into, nor is it the right audience to go into much detail here, but I'll just link it. Maybe the most interesting thing to do is link it to what Yvonne was just saying about the policy paper that was issued on gender persecution. In that, the sort of basic conceit of the book is that the concept of gravity of crimes is doing and has done a lot of work at the ICC and international criminal law more broadly, but that the concept itself is very poorly defined and understood. And that the problem with that is that it then enables arguments to be made that aren't very well founded because they're based on a very ambiguous idea. So that some of the arguments made, for example, regarding jurisdiction or decisions taken concerning jurisdiction aren't necessarily as well grounded as they ought to be because they invoke this ambiguous concept. So as everybody knows, the basic purpose of the ICC is to prosecute those responsible for the most serious crimes of concern to the international community as a whole. And that very mandate embeds this idea of gravity of crimes. What are the most serious crimes that are a concern to the international community as a whole? And this policy paper concerning gender persecution, I think, is an interesting statement by the OTP about one aspect of what that means, right? Where the OTP is saying, we really want to focus on crimes in which people are being persecuted based on their gender. And we believe that that includes a very capacious understanding of what gender means and so on, right? And so that idea about what is included within the idea of the most serious crimes of concern has certain consequences then, right? About what the OTP is how they're going to investigate situations and cases, what they're going to focus on, what cases they might bring within situations, and even potentially what situations they may choose to pursue. And interestingly, as a side note, pretty recently, the appeals chamber found that the OTP has discretion. This was in the Afghanistan situation. But one of the more important decisions that I think maybe hasn't gotten as much play as it ought to in the commentary, because in the past, the OTP had taken the position that it didn't have discretion, that any situation that fell within the ICC's jurisdiction had to be pursued. And the appeals chamber has said, no, there is discretion there. And this opens up the door then for the ICC to put into practice its own vision of what the most serious crimes are at this situation level, not just in the sense of picking cases within a situation. So what does that mean? Well, the ICC may now pursue a situation, for example, that involves gender persecution, maybe even to the detriment of another situation, let's say that involves a lot of killings, and maybe even sort of quantitatively more deaths or more harm, but that's not based on gender persecution. And so I think that's a really important development, and it's one that deserves a lot of attention and commentary. And it sort of begs questions about what is the ultimate role of the ICC in the world order, and what are the purposes that should guide the court's decision making, especially in things like selecting situations. And here, I think, I'll just put my perspective on the table, which, as I elaborate in the book and elsewhere, is that the ICC ultimately really is about global norm expression, and that expressive purpose of the court is its most important role, and therefore that it is valid to, for example, pursue a situation or cases involving under-prosecuted crimes that particularly need expression. And gender persecution, I think, falls squarely within that, right? As does crimes of gender and sexual-based violence. And I think the OTP has taken the position that crimes of cultural heritage, child soldiering, there are certain crimes that may not be the most quantitatively grave, but that need particular global attention in order to promote prevention worldwide, and then that's a good reason to pursue these kinds of crimes. So that's sort of one aspect of what the book's about and what we talked about in the side event. And I, again, just really grateful to all of those who contributed their brilliant thoughts and took the time to take a look at the book. So thanks.
Thank you. Now, my next question has to do with the Office of the Prosecutor's launch of the annual report. This was also one of the major events at the ASB. The report identified some key thematic priorities for the office, such as bringing the OTP's work closer to communities and building partnerships with civil society. And these were definitely some major topics of discussion during this event. Could you share some of your thoughts regarding the launch and how the OTP's annual report addresses these calls from civil society organizations to ramp up civil society participation? So maybe I'll start with Yvonne and maybe go back to Meg as well.
Yeah, I'll just say there was a lot of participation from civil society organizations at that launch. They seemed very interested in gaining the prosecutor's attention and making sure, you know, that the prosecutor was aware of the situation in their, you know, in their country or in their region or in the victims that they might represent, things like that. I think that highlights so much that, you know, again, we go back to a court that has a lot of people rooting for it to be the answer to their justice problems. And I think it's something that we've talked about before. And it's something that the prosecutor keeps highlighting, which is with the resources that he has been given and the ICC has been given, and with the many demands that the office take on these matters, you know, it needs more resources to get that done. And he's trying to manage the many demands on his time with, you know, with the very complex and difficult investigations that he has ongoing already. And so he's trying to manage a lot. One thing, you know, that I thought was interesting was, and I think this is one way to sort of address this in some ways, is the prosecutor is talking about ways to, because there are so many demands, what can be done to make sure that justice is done in these other situations. And there was a large focus on dynamic complementarity and cooperation. And the idea here is that, you know, it's not outsourcing, but if the prosecutor can help others and help the jurisdiction itself, or if others can jump in and be part of a team to help the prosecutor, you know, we can sort of expand the resources that are going to go towards providing justice to these many victims. So there's a real focus. The prosecutor talked about working with joint investigative teams, and we know that that's ongoing with Ukraine right now, where national domestic personnel and also seconded experts from other states are assisting the prosecutor's office here. So getting extra personnel here, right? So this assists with the resources. Office also talks, you know, it talked about not only with Ukraine, it talked about, well, with Libya, it's also having a joint team there. And that team was created in September 2022, and it's aimed at supporting investigations into crimes against migrants and refugees in Libya, joining relevant national authorities from Italy, the Netherlands, the United Kingdom, Northern Ireland, and Spain, and, you know, being supported by Europol as well. And so I thought that this was you know, an interesting development that was being highlighted here, and really trying to address this, you know, the many needs that are out there and the many calls and demands on the prosecutor's office to provide justice. You know, this is just one way to address it. I'll turn it over to Meg or Kate to speak to.
Great, thank you. Meg?
Yeah, just a couple of thoughts to add there. I think it's very interesting that Prosecutor Khan is taking quite a different approach from his predecessors. He is very clear, and I think the word that keeps coming to mind is unapologetic, and he might have used that term himself when he was describing, you know, I think he is trying to be very clear about the difference between his approach and that of his predecessors, which is that he's going to be, in his words, directed and nimble. He's not going to try to do everything for everybody. He's going to select what he thinks are the best priorities for the OTP and be very targeted and focused on those. And he made that clear from the beginning of his tenure when he closed a couple of preliminary examinations, which had not, which had been open for years and years. So what that means, and he's aided by this decision of the appeals chamber that I mentioned a moment ago, allowing discretion to pursue some situations and not others. And so it's quite clear that he is going to pick. How he is going to pick is not as clear. And that's what I'm really interested to see. He didn't really answer, I thought, very clearly some of the questions that people asked about, why this and not that. Maybe the most controversial thing or one of the more controversial things that he's done so far is to state that he's going to prioritize investigating crimes of the Taliban and the government in Afghanistan and not the United States, alleged crimes of US citizens. So, I mean, of course, he didn't emphasize that latter part. He emphasized the first part, that he's going to prioritize the crimes of that. So that is really interesting, right? What are the criteria? How are they going to be applied? This is an area where I think civil society really should continue to pay close attention and to sort of hold his feet to the fire in terms of explaining what he's doing. Then Deputy Nyang said something that I found really interesting, which was that complementarity is not just about national prosecutions, but also regional and sub-regional prosecutions. This is something that I've been interested in for quite a while, since the reinvigoration of talks about having a criminal jurisdiction at the African Union, which haven't gone anywhere much in practice in terms of implementation. Largely, I won't go down that rabbit hole, but it hasn't become a functional institution yet. But there are apparently talks now of having ECOWAS become involved, for example, with potential prosecutions related to the Gambia. So potentially, the comment that Deputy Nyang made me think that this is a trend that the ICC may be taking pretty seriously, and that we may be seeing more activity in that regard in the future, which would be really fascinating. And then Deputy Ka said something interesting about supervising at a more granular level. So I think there's been quite a restructuring of how things work within the OTP, and that the sort of levels of supervision are going down to a more granular level. So that's also something to watch, especially in terms of workplace culture, which has been really a focus of the OTP. I think is, that the report of the experts was quite critical of workplace culture within the ICC, and in particular the OTP. And so how this new operation with more granular supervision will affect that, I think will be really interesting to see. So those are a few thoughts.
Thank you. Now, I did want to go back to Kate. Kate, if there's anything that we discussed over the last few minutes that you want to comment on, please go ahead. But also, I did want to go back to this issue of, I want to say like defense rights, but protections for these amazing lawyers who are members of the various defense teams. So one of the things that you mentioned is that there was this somewhat unprecedented decision made to not allow defense counsel to participate in the ASP. So to your knowledge, were there any significant discussions of sort of defense rights and defense counsel at the ASP at the more formal level? And then are you aware of similar issues happening at other courts other than the ICC?
Thanks very much, Milena. Maybe firstly, I'll just jump on the back of some of the comments of Meg and Yvonne about the prosecutorial strategy and the new approach of the ICC prosecutor. Just to say that, I think we found it very interesting that in the week following the ASP, we saw that the prosecutor was really sort of following up his words that we heard at the ASP with actions, releasing this statement on the 16th of December saying that I'm going to be closing our investigations in the situation in Georgia, and then issued a similar statement in relation to investigations in the Central African Republic. And one of the things that I find refreshing about his approach is that he's so open in talking about the need to be robust in relation to resources, and saying the Office of the Prosecutor has to sort of stop over promising and under delivering in relation to, you know, essentially victims who are sitting and waiting for justice in these various situations. And he's just been incredibly pragmatic in terms of making these decisions. So I thought it was interesting that those declarations from the Office of the Prosecutor sort of came out so shortly after the launch, as we saw. But in terms of whether there was any sort of concrete follow-up from the defence strike during the ASP, certainly the ASP itself issued this second resolution on strengthening the ICC and the ASP, in which it included a paragraph 92, in which it requested the court to consider interim measures that would benefit the victims and defence teams within the existing budgetary structures. So, you know, the right sort of sentiment, but so far there's been no sort of concrete actionable follow-up from that paragraph. In terms of whether similar issues are affecting independent counsel at other courts, I mean, hands down, the ICC rates of remuneration and working conditions of independent counsel are, you know, the lowest and the worst across the different international criminal courts and tribunals. And that's been confirmed by sort of independent studies of the ICC's legal aid policy. But I think the larger problem is really that we see after, you know, 20 years now of independent counsel, of defence counsel appearing in front of the international courts and tribunals, and the huge gains really that were made at the ICTR and the ICTY in terms of the defence being recognised as sort of a central actor in this international criminal justice project. Things at the ICC are really at risk of going backwards, with defence teams and victim teams having to again sort of fight for the same rights and recognitions that we had already in front of the other tribunals. I'm very aware that this campaign around defence and victims' rights is going to continue, and the really incredible, wonderful, mainly junior lawyers who are spearheading it are really determined to keep fighting for what they see as sort of a central fair trial issue. So I guess watch this space and bring on ASP 22.
Looking forward to the next ASP already, Kate. Now, my next questions are to all the panelists and have to do with major developments that took place at the court over the past year. So let me start with you, Kate. Any particular developments at the court over the last year that you would like to highlight for our audience members?
Yeah, I mean, as always, there was sort of an abundance of really interesting decisions across the different cases. In the Ntaganda case, for example, we had this sort of significant appeals chamber judgment on reparations that overturned in significant part the reparations order that had been issued by the trial chamber. And in a judgment where the appeals chamber really gave us a lot of new guidance about how reparations at the ICC can and should work, and in particular the involvement of the convicted person in that process. One quite high profile decision came late in October in the Afghanistan situation, where the pretrial chamber authorised the prosecution to resume the investigations in Afghanistan into all crimes, alleged crimes that had been identified by the prosecution when the OTP sought to trigger the investigation back in 2017. And Meg's already touched on this, but this decision we saw prompted a lot of sort of calls from civil society groups, victims groups, human rights groups, urging the prosecutor not to be selective and to sort of urgently investigate all parties to the conflict, including, you know, the ANSF and the US military. And so it would be really interesting to watch developments in that situation. One thing I found really interesting was the request in November from the prosecutor to pretrial chamber 2 in the case against Joseph Kony, where the prosecutor sought authorization to hold a hearing on the confirmation of charges in the absence of the accused or the absence of the suspect, which is the first time that the prosecutor has made a request like this. So, immediately lots of commentary about, the right of the accused to be present under Article 63 versus, the entitlements of victims to justice after 17 years. But I think really, or certainly the public narrative around the ICC's work in 2022 really focused on the court's reaction to the Russian invasion of Ukraine, which we spoke about at the beginning of this panel. What I think was particularly significant was the coordinated action that we saw of over 40 states parties in referring the situation in Ukraine to the Office of the Prosecutor in March 2022. And this was significant because, as we're all aware, neither Ukraine or Russia are states parties. Although Ukraine has lodged these two declarations in 2014 and 2015 under Article 12.3 of the statute. But, we saw in February, on the 28th of February, the prosecutor, Karim Khan, said, I'm going to go to the court and seek authorization to open this investigation on the basis that there's a reasonable basis to believe that both alleged war crimes and crimes against humanity have been committed, but he still needed authorization from the court to open the investigation. And then in the days that followed, the 1st and 2nd of March, we saw this wave of states parties, starting with Lithuania, referring the situation. A whole host of states, Australia, even Canada, France, Norway, Costa Rica, I think about 43 states joined this call. And sort of many people saw this as a sort of reinvigoration of state party support for the ICC, and also in its sort of confidence in its ability to act and act quickly in situations of mass atrocities. And Meg and Yvonne have sort of discussed the differences of opinion that we can see emerging between those who are calling for a special tribunal and Prosecutor Khan's approach. These dynamics have been really interesting to watch on a PRLPG panel. In sort of the end of last year, we saw the Ukrainian prosecutor, Yuri Belousov, who heads up the war crime section of the Prosecutor General's office in Ukraine, saying that we are determined to prosecute the vast majority of perpetrators domestically in front of Ukrainian courts, and acknowledging that only a small number of perpetrators would end up in The Hague, and really calling on states saying, if you want to help contribute to this sort of matrix of accountability that's arising, you should be sending expertise and resources to our offices to help us do this domestically. So it's just going to be really interesting to watch how this unfolds. And of course, we are hoping beyond hope that there's a swift resolution to the horror that we've been following in Ukraine over the past year. So those were some of the highlights as I saw them in 2022.
Let me go to Yvonne next. So any highlights, and in particular, if you allow me to ask a leading question, the Ongwen case. Can you talk a little bit about the Ongwen case, which, there are several decisions involving Dominic Ongwen over the last year?
Yeah, I won't say much about it because I know that we're going to run short in time. But I was able to participate. PILPG put in a amicus brief for the appeal in the Ongwen case. And we spent some time talking about a question that really has not been addressed, right? And this is the burden of proof regarding the existence of a mental disease or defect or duress under Article 31 of the Rome Statute and Article 79 of the Rules of Procedure and Evidence. And we noted that given that there's no provision, we went through some history, the history of the creation of the Rome Statute and the rules of procedure as well. And we suggested that that the evidentiary production approach would be appropriate, where the court would place an obligation of initial evidentiary production with respect to a defense of mental disease or defect or duress on the accused. And thereafter, right, the burden would maintain on the prosecution to prove that the evidence brought forward does not raise a reasonable doubt about the accused's culpability. And we suggested that this was most appropriate given the language of Article 31 and given the history of the creation of that rule. There was a decision December 2022, December 15th, by the appeals chamber on the Angwin matter. And I think that had been awaited for a very long period of time. The conviction, I will say, it just short form here, the conviction was upheld of Dominic Angwin, and that was the final thing. And the only other thing I would like to say, just sort of in closing, is I sort of echo Kate's point about, I think it's a year that we're going to watch the court a lot here, and I think everyone is focused on the court. The Ukraine situation, gave a lot of impetus to that, and I think we're all going to be watching the court and everything that it does, basically, for a number of the reasons that have been raised here today.
Thank you. Meg has the last word here. So Meg, either you can talk about any key developments from last year, or perhaps, even more interesting for audience member, can you foresee, if you had a crystal ball and could predict the future in terms of the ICC, what do you think are some of the issues that the court will be dealing with in 2023?
That's a capacious question to which I will give an inadequate answer in the next 3 minutes. I think one thing that we're going to see is a continuation, at least for now, of the energy, the sort of high energy level around all things ICC and ICL in general. I think that in The Hague, there was a palpable sense of kind of excitement about the efforts that are being made in not just with regard to Ukraine, but kind of around the world. And I think it's fair to say that a lot of that renewed energy is due to the Ukraine situation and to the very clear demands for justice that are reverberating around the world as a result of that conflict. But I think that there are many, many ways in which that has spread. And I think we're going to continue to see that. So I think there'll be a lot of renewed efforts toward universal jurisdiction that will help the ICC by kind of fulfilling some of the anti-impunity mandate at the national level. Like I said before, I think I'm optimistic anyway that we'll see developments at the regional and maybe sub-regional organization level that will also contribute. I think we'll see increased United States participation in anti-impunity efforts around the world, including helping the ICC in very concrete ways. For example, by issuing more rewards for assistance to law enforcement in capturing fugitives. That's something that I think is completely conceivable to see as an increase in US participation in the ICC's efforts. I think we'll see a court that is leaner and more targeted. And I think there'll be controversies around that. I think it'll be difficult to justify focusing on this situation and not that situation, or these cases and not those cases. But that dialogue that will hopefully take place, and I agree with Kate, one of the things that is really great about Prosecutor Khan is his direct communication with the world about what he's doing. And that really fosters a dialogue, or can foster, and I think has been fostering a dialogue with those interested in supporting the ICC, or even just talking about the ICC, where norms about the ICC's role can be developed. So in sum, I know we're out of time. I think it's an exciting time for the court, and I look forward to seeing what the year ahead brings.
Thank you. Unfortunately, we are out of time. Thank you for joining us and submitting your questions. The webinar recording will be available on the PILPG website and shared with all of the attendees on Zoom via email. I would like to reiterate that this event was part of the PILPG Thought Leadership Initiative Expert Roundtable Series. We organize periodic expert roundtables and share our expertise and insights on various topics of international law and international affairs. Thank you again to our panelists for sharing their takeaways from the last ASP, and to all of the attendees for contributing to this crucial discussion with their questions. And I encourage everyone to follow this initiative and join us for our next event. Thank you.
Thanks very much. Thanks, Milena.
Thank you all. Great to see you.